under negotiation of the instrument itself for full value. I covered this once before. So essentially what the state requires, let's talk about local laws of jurisdiction. We can talk about Texas. That's a pretty easy one. 192.007 is the state statutory requirement for local laws of jurisdiction to enforce the deed of trust lien encumbering the property. So essentially what the state's requiring is that you illustrate and prove in terms of proof of claim that you're the holder of the debt, the tangible instrument, and that you can illustrate that you've acquired it's incumbent upon a successor and interest statutorily in terms of proof of claim to illustrate how they came into possession of the instrument and whether or not they acquired that instrument statutorily with rights to enforce the debt. Moreover, rights to enforce the debt over the mortgage lien. Okay, so that can only be derived from proper negotiation and transfer of rights in the instrument, a true sale. Okay, and again, this is what the banks are typically coming to the courts with, is a copy of the note as it exists today with a no payee named as a bearer instrument, and they're citing that they physically negotiated the instrument, maintaining perfection over the lien in a bearer capacity, right? Well, we've already covered that could not have happened in an ordinary course of business, because an ordinary course of business would mean that the original lender executed a contract with the homeowner as if the homeowner was in the capacity of the beneficiary of the debt. Well, in order to be the beneficiary of the debt, you have to be the entitlement holder to the instrument, negotiating your promise as an entitlement holder. Again, we've covered in the exchange transaction, the order of operations. The homeowner's signature on the instrument and negotiation of the instrument is not step one. The bank accepting the instrument and depositing the instrument and giving consideration is not executing a contract. That didn't take place. Therefore, to create an order paper and call it a bearer instrument under 3205B with no payee named doesn't constitute negotiation in bearer form, okay, under 3205B. This is the biggest challenge that everybody's having in judicial and non-judicial litigation. They don't know how to discern how to challenge their proof of claim as being a holder of the debt. Oh, well, they're a holder of the note, so they caused an assignment of the security instrument for transfer of enforcement rights, so they must be the secured party of record. Nobody else, no other financial institutions challenging their secured party status. So you're still in possession of the collateral. What's the issue, right? How have you been harmed? That's the million-dollar question. Well, you're not going to be able to defend the collateral if you continue to make an admission that you negotiated your note in your promise to be the beneficiary of the debt. You're acquiescing into a transaction that did not take place at all. Okay, what you actually signed in, and I want to make sure and cover this here. A document is duly negotiated if it is negotiated in the manner stated in the subsection to a holder that purchases in good faith without notice of any defense against a claim, which is essentially a true sale, and for value, unless it is established that the negotiation is not in the regular course of business or financing involves receiving a document in settlement of payment on a monetary obligation. Well, what does that mean? Okay, well, let's talk about what that means. Okay, so 3419 is the accommodation of the tangible instrument. This is the conversion or statutory conversion of the instrument. Okay, delivery required. Let me go back to, I gleaned the information I wanted to cover here. So this is where that particular article is where, one second. This particular article here is where we glean this information. Okay, so 3420, delivery required. The debtor customer was not an authorized agent to receive the checks on behalf of the factoring company. The California Courts of Appeal has held that the factoring company, right, must be able to illustrate that they were delivered the instrument in accordance with the statute, okay, or else their claim is invalidated. So for those of you that can prove that they never were delivered the tangible instrument, that's going to be an important statement of fact, obviously. But the stripping of the receivables through conversion and whether or not revised Article 9 applies to the lien on real property, we're getting to the root of the issue here, okay? So big thing that I wanted to make sure is that this is not We know now that the note wasn't negotiated in an ordinary course of business. We know now that the homeowner is not an account debtor, and step one is negotiation, acceptance, and consideration, a contract. That didn't happen. We understand order of operations now based on the SPV 1031 exchange chart. Okay, so what is the special purpose vehicle making a claim to? Well, they're essentially stating here under 9, let's go to 9203G. Let's do that real fast. 9203, attachment and enforceability of security, interest, and proceeds, supporting obligations, formal requisites. So this is the common law rule that everybody gets beat with the tangible promissory note in bare form. Lien securing right to payment. The attachment of security interest in the right of payment or performance secured by the security instrument or lien or personal real property is also attached of a security interest in the security interest, mortgage, or lien. Okay, so essentially what they're claiming is a transfer of an obligation carries the beneficial interest evidenced by the lien and the lien itself to the successor. Okay, so that's how they're able to make the connection to maintaining a beneficial interest over the lien while negotiating the tangible instrument in bare form under a purported ordinary course of business. Okay, so this is the lie here, that they negotiated the note in an ordinary course of business and that the common law rule 9203G maintains perfection over the originally recorded lien. Therefore, they can make a bootstrap assignment of the deed of trust lien for rights of enforcement at any time, and that's where you're seeing the MERS assignment being executed years later after the closing date of the REMIC trust. Okay, so for you, those of you that are paying attention, that's what they're claiming. They're claiming we were negotiated the note. We don't have to maintain a chain of title. It was negotiated in bare form. Under 9203G, we maintain perfection over the originally recorded lien. Therefore, we're just bootstrapping our interest years later to enforce an in-rem action against the real property, enforce an alternate means of collection. Okay? So they're claiming, just to reiterate here, they're claiming true negotiation. They're claiming that it was duly negotiated, okay, in a matter stated in the subscription as holder that purchases in good faith without notice of any defense for value, okay? What we're saying is, no, you didn't, okay? What you actually did was an IRC 1031 exchange, right? Let's go back to that chart again, where step one, you induced certificate holders through special deposit, right? You sold cash flow purchases of ABS securities. So you sold the securities under the 1933-34 Exchange Act. You submitted your prospectus supplement and you dumped the securities on Wall Street. Okay, so now the securities are sold and they're in special deposit. Now you have the deposited funds to create the line of credit for the exchange, right? So here are your qualified intermediaries who send the warehouse line of credit down to the sponsor bank and originator at the closing table to table fund that obligation, in which the originator is the account debtor as accommodated party, and you are the guarantor, the homeowner is the guarantor on the obligation and providing the real property collateral to secure the accommodated party status so that they can use your name and creditworthiness on the obligation as accommodation party and pledge the real property into the exchange to create the offering on the secondary market. That's just what happened, bottom line. It's all here for you to vet, okay? So again, that's covering step two, the credit swaps, okay? And that goes backwards and forwards in terms of the asset coming back to the REMIC and securing before the cutoff date of the REMIC, maintaining perfection over the obligation as trust property, okay? Again, here is the supporting cases on the exchange for non-simultaneous exchanges on real property and the requirements of qualified intermediaries and the entity structuring for the tax pass-through structure, okay? So this stuff is understanding the entity structuring, the Tax Reform Act of 1986, the Starker case on order of operations and what's taking place, and the requirements of these parties in the entity structuring and their statutory capacity. So what's actually taking place, what are they actually negotiating, and what is the REMIC making a claim to, okay?